I think it's worthwhile to take just 30 minutes to make sure that you're in compliance. To be going through some common scenarios that give rise to fair housing issues and looking at the policies and procedures to address them to make sure that your office and your property is in full compliance with fair housing. We'd like to thank Mishta for sponsoring this and other webinars. Really appreciate their support. There's more fair housing webinars available on our website at fairhousingdetroit.org under services and resources, and it's a growing list. You can also go directly to YouTube for a listing of these other webinars. But thank you so much, Mr. for their support. Down to 29 minutes by way of introduction, right? This webinar is going to discuss the most important fair housing compliance issues that face housing providers and how to address them. Now, other than stating common violations, this webinar is not going to get into any detail about what constitutes, what does not constitute a fair housing violation or give rise to housing liability. Rather, those are addressed in other PowerPoints and videos. This one's going to deal just with compliance issues and what housing providers need to do. So it's just like the title says, it's going to be a compliance check. So by way of just a quick introduction, what do you think the leading transaction type that gives rise to a fair housing complaint? Rental, sales, lending, insurance, and so forth. It's rental. 83% of the claims rise out of the rental situation. And what's the leading complaint basis? Race, disability, familial status, sex, national origin, and so forth. Disability, 52%, close to 53%. And you can see the second most common category is race. The other categories fall a distant third, fourth, fifth, and so forth. Other category is close to 17%. Of the other complaint basis, what do you think the most common one is? You can see the listing here. It's actually source of income. Again, these are based on the National Fair Housing Alliance 2024 Fair Housing Trends Report. And which reporting agencies are most likely to receive or be the source of a fair housing complaint? Department of Justice, HUD, state and local agencies, and state of Michigan here is the Michigan Department of Civil Rights, or fair housing centers. Well, overwhelmingly, fair housing centers, 75% of the fair housing complaints come out of fair housing centers. So I think you want to get the fair housing training from the fair housing centers because we're the groups that bring the majority of the claims. And you can see the percentage here, how tiny it is. The DOJ may get a lot of attention with, big kind of systemic type complaints, but really the fair housing centers are where most of the complaints come from. So number one was disability. What is needed from a fair housing compliance check in terms of disability? There's three compliance issues that come up with disability or give rise to disability discrimination complaints. One is a lack of written reasonable accommodation, reasonable modification policy. Some places don't have them at all. There's failure to review applicable HUD regulations and HUD DOJ joint statements or policy statements. And then the third one, there's unwarranted requirements as to assistance animals. When I use the term assistance animals, I'm referring to both emotional support animals and service animals. They all fit within the umbrella term assistance animals. So for compliance, we have a sample on our website, reasonable accommodation modification policy. It's right there on our website at fairhousingdetroit.org under services and resources. Download in Word format, and you can customize it as you need to be. The sample reasonable accommodation modification policy. Just to go through really quickly on it, you can see it has a specific policy. It lists if someone is concerned about a response or want to look at it further, so forth. Attachment A to the policy has the reasonable accommodation, reasonable modification request that a prospective tenant or current tenant or current occupant, you can use this for an HOA, condominium property, and so forth. And they can ask specifically what they're asking for, a physical change or a change in rule, policy, or procedure. People are not required to put their reasonable accommodation modification request in writing. It's helpful for everybody involved if it's done that way. But even if they don't, then the office should be then processing, writing up for the person just so it doesn't fall through the cracks. See if requires a physical modification to the premises, the landlord may condition allowing a modification on the requirement of the renter to restore the interior of the premises that existed before the modification was made, reasonable wear and tear accepted. Attachment A is to be completed by the resident manager if the requester cannot or will not complete the form. This is where someone will make an oral request. The manager or whoever is responsible official will then fill out the form on behalf of the person who is making an oral request. Again, you don't want requests to fall through the cracks. Then there's a form where the housing provider either approves, doesn't approve, or requires further information, for example, going through the interactive process. This is a form that can be used to respond to the reasonable accommodation request. And here's the second page of it. Attachment C, you can see of this policy, is a form that you can be given to the medical service provider to confirm the person's disability. And you can see, and they're at the bottom here, you notice there's a release where the applicant can give a release so that the healthcare provider or medical service provider can talk if necessary or provide records to the housing provider and permits that release. Now, here's information that's being requested from the healthcare provider. This is information that can then be sent to the healthcare provider to confirm that the person has a disability. The important thing about this is a policy that got approved in a consent judgment through Department of Justice, so it's a court-approved reasonable accommodation modification policy. Second thing is, when it comes to reasonable modifications, always take a look at the HUD regulations for reasonable modifications of 24 CFR 100.203, and there's a HUD DOJ joint statement on reasonable modifications under the Fair Housing Act. This was promulgated in March 2028. It's not saying it's binding law. However, courts, in the absence of other authority, will look to these policies in determining what a housing provider should do. Courts often just adopt it as requirements under the Fair Housing Act. The regulation came out in 1991, so it went into effect. It's been over 30 years. If people are still not following the regulations, and that can have the force of law in most situations, it shows that they're really not interested in fair housing compliance. So really, you've got to look at that when it comes to reasonable modifications. You've got to look at the regulation and the joint statement. For example, if the tenant asks for grab bars to be installed, at whose expense? Well, if there's no federal financial assistance involved, it's not a HUD property, so forth, then it would be at the tenant's expense. If it is federal financial assistance involved, then it would be at the landlord's expense. Do you have to remove grab bars? Should that be something that the tenant should bear the expense? Regulation says it is something that the tenant can remove. Doesn't mean you have to require the tenant to remove it, but you may. Talks about whether doorways that have been widened for someone that's a wheelchair user, should the doorways then be restored to a more narrow condition as existed before the reasonable modification request and change was done? HUD says no, it does not have to require, it should not require that the doorways then be narrowed to their original width. So it's important to look at the regulations and the joint statement. Same thing when it comes to reasonable accommodations, starting with the HUD regulation implementing the reasonable accommodation provisions of the Fair Housing Act 24 CFR 100.204, then go to the HUD DOJ joint statement on reasonable accommodations under the Fair Housing Act. This is the May 2004 joint statement. You've got to look at those. When it comes to municipalities, you look to the HUD DOJ joint statement on state and local land use laws and practices and the application of the Fair Housing Act. When it comes to assistance animals, there's one-stop shopping on that statement by HUD, assessing a person's request to have an animal as a reasonable accommodation under the Fair Housing Act. And then for place of public accommodation, HUD, the DOJ has an FAQ, frequently asked questions, about service animals and the ADA. And here's a caution for everyone, please do not go beyond the 2020 guidance. Some do. We see these violations quite often, requiring, for example, that the disability certification be provided by a licensed physician, or requiring that the physician be located in the state, requiring that the assistance animal be spayed or neutered. It's one thing to say that the animal should be have a proper license with the municipality or proper vaccination status. That's all fine. but spaying, neutering, what's the reason for that? Probably not necessary and can be regarded as a burden or obstacle on someone's right to ask for and receive a reasonable accommodation. It also gives guidance on internet certifications where there is no patient-provider relationship, and the guidance will really be helpful with that. So that's the main ones, compliance issues when it comes to disability. The next most common category of fair housing complaints are in race or color. The main one we see is an overbroad criminal record or overbroad or blanket criminal record policy. And here's the questions that someone should be asking from a compliance standpoint. What's your look back period? 10 years, 7 years, 5 years, 3 years, other? What do you consider in terms of someone being released from incarceration date? Or if they were incarcerated for 10 years, the conviction happened 12 years ago, they've been out for 2 years. So would you consider from the date of conviction or release from incarceration? Probably you're looking at release from incarceration date. And do you distinguish between the various types of offenses? If so, what basis do you use? And do you permit the applicant to provide evidence of rehabilitation or other mitigating information? For criminal record policies, the key starting point is a HUD Office of General Counsel, April 4th, 2016 policy or guidance statement, application of the Fair Housing Act standards as to the use of criminal records. HUD also did an implementation of the Office of General Counsel guidance. That implementation was issued June 10th, 2022. There was recently or last year a notice of proposed rulemaking reducing barriers to HUD-assisted housing. That was issued in April 2024. It was withdrawn in January of this year. Even though it's withdrawn and not into effect, it still contains helpful guidance. When it comes to public housing, there's a HUD notice, Public Housing Notice, PH 2015-19 should be what someone should consult to. HUD also has PHA regulations on governing denial of admission and lease termination. So recommendations. Clearly, you got to check state legislation, local ordinances for criminal record requirements. Have to check it. I see violations where an ordinance gets adopted pertaining to criminal record requirements and the housing providers don't even look at that. Meeting the local standards doesn't mean it's acceptable necessarily under the Fair Housing Act, subject to both requirements. So if there's a lesser standard, like I could show you a way under Detroit's Fair Chance Ordinance where it's overbroad and compliance with the Detroit Ordinance would not protect somebody for liability under the Fair Housing Act as to criminal record standards. The guidance and the suggested policy here will be acceptable under both at the local level and at the federal level, with some exceptions. So again, you still have to use both. If you draft your own policy without using examples, you should be aware that overbroad policies can result in an unlawful disparate impact or effect on protected groups, or two groups, particularly Black and Hispanic applicants or tenants. Also, courts look to see that you have empirically evaluated or empirically validated the effect of the policy. If you come up with a 7-year look back period, on what numerical basis did you do to adopt that policy? That's where the challenge comes in. Carefully consider look back periods. You can't exclude persons with conviction of illegal manufacture, distribution of a controlled substance, or lifetime sex offender registrant. And you have a written policy, you should have a written policy for termination of occupancy based on criminal activity. Consider mitigating information and the types. The policy should spell out that. Provide notice to applicants as to your criminal record policy and keep all criminal records and other information strictly confidential. And be alert to other types of discriminatory conduct. For example, alcoholics, former drug users will often have a criminal record. They may be entitled to reasonable accommodations as to their criminal records. I have two policies on our website. I've got a long version and a short version. I like the long version. I think some people may be more comfortable with the short version, but go on there, download it. It's in Word format. You can make the edits, change the names to fit your housing situation. So next is familial status. What do we want to look for a fair housing compliance check as to familial status? The big one is the overly restrictive occupancy policies. In other words, people are using 2 persons per bedroom unit that's the law. 2 persons per bedroom unit. It's a 1-bedroom unit limited to 2 people. It's a 2-bedroom unit limited to 4 people. But that's just the starting point, not the ending point. And so the Fair Housing Act does adopt or does recognize state, local, federal restrictions regarding maximum number of occupants. We'll see that in a second. And they does permit housing providers to establish their own reasonable occupancy standards when they are reasonable. In 1998, Congress required HUD to adopt a memorandum outlining these factors. It's known as the Keating Memorandum. It was adopted. HUD went away from it. Now they came back. The Keating Memorandum is the controlling standard for occupancy policies. Is 2 heartbeats per unit acceptable, or must other factors be considered? Other factors must be considered. We're going to look at it here in the context of an example. If there's a 1-bedroom unit, 10 feet by 14.5 square feet, that would end up being what? 145 square foot in that 1-bedroom unit. Or a 1-bedroom unit, that's 11 by 14 square feet. If my math is right, that's 151 square feet. Correct me if I'm wrong. And then the 2-bedroom unit that has 145 square feet, 151 square feet. How many people can occupy those 3 rental units, and what factors must be considered? So again, we're looking to the Keating Memorandum. If you look it up online, it'll pop right up. Keating Memorandum says it's presumptively reasonable, an occupancy policy of 2 people in a bedroom unit, but you still must consider other factors. The factors are listed at the bottom of the screen. So you've got to measure the square footage of each bedroom in each rental unit that you have. Look at the local building code for occupancy and square footage requirements. If there is no standard, use the standard in the International Property Maintenance Code. Then consider the remaining factors listed in the Keating Memorandum, and then you have an occupancy policy that will be in compliance with the Fair Housing Act. You can see Detroit has 70 square feet to constitute a bedroom unit, and then it's 50 square feet per person. It doesn't mean 70 plus 50 plus 50. It means 70 to constitute a bedroom unit. If it's 70 square feet, it's good for 1 person. Once it gets to 100 square feet, 2 people, 150 or more, 150 square feet, 3. And Dearborn requires, believe it or not, 100 square feet. And every room occupied for sleeping purposes shall contain at least 50 square feet of floor space for each occupancy. So it's a 50 square foot minimum requirement for a bedroom unit, but again, 50 square feet per person. Ann Arbor is a little bit nuanced. It's 50 square feet for adult. For each occupant under 12 years of age, 40 square feet. Port Huron follows, like most of them, 70 square feet to constitute a bedroom unit, but it doesn't specify how many square feet per person. So again, in Port Huron, you'd have to go to the International Property Maintenance Code. Grand Rapids, in Warren, Sterling Heights, Lansing, Clinton Township, and Birmingham all adopted different versions or various versions of the International Property Maintenance Code. So what is the International Property Maintenance Code? Here's the 2015 code. Every living room, 120 square feet. Every bedroom shall contain not less than 70 square feet. And every bedroom occupied by more than 1 person must have at least 50 square feet per occupant. So the correct understanding is 70 square feet for 1, once you get up to 100 square feet, 2 people, 150 square feet or more for 3 persons, etc. But you still got to look at the Keating factors. It's incorrect, and there was a court where the housing provider was found liable because they did this incorrect computation of doing 70 square feet for 1 person, and they were requiring 120 square feet, adding 50 to the 70, 120 square feet for 2 persons, and then adding 50 to 120 to make 170 for 3 persons, etc. That is incorrect. So how many persons can occupy the following? The 1-bedroom unit, 10 by 14.5 square feet. The general rule is 2, but depending on the age of the children and any local building code standard, could possibly be 3. A 1-bedroom unit, 11 by 14 square feet, 3. A 2-bedroom unit, again with 10 by 14 and a half and 11 by 14 square feet, that's going to be 5, possibly 6, depending on the age of the children. And the other factors that must be considered are listed down here. For example, a newborn you don't need another bedroom if a newborn comes in. At what age do you need to require them to move into a larger unit? Law is uncertain. Doesn't specify that. I would think around 6, 7, 8, but it's not clear. Maybe even earlier, but it's not clear. But again, you can't just go 2 persons per bedroom unit, and that's the law, without going and looking at these other factors. What are the compliance issues when it comes to religion? Limiting or restricting the use of rental or other residential housing due to religious practices of tenant owners, occupants, or their guests. There's 2 policies as to this. There's a HUD memorandum, Ensuring Fair Housing Amidst Ongoing Religious Discrimination in the U.S., that came out in May of 2023. And then HUD Office of General Counsel did a letter to Heritage Court Associates, May 19, 2006. And you can see the HUD memorandum, the May 2023. It describes samples of what would constitute fair housing violations based on religion. And you can see those are listed there. I'm not going to, so here I'm under at 7.5 minutes to go. I'm in a hurry. Then the HUD Office of General Counsel letter to Heritage Court, they were restricting, they asked, can they restrict the community room for religious purposes? And it says here, can they do it? Can they allow religious activities, Bible studies, and so forth in the community room? Yes, provided that the community room or community facilities, if they're available for other groups or other religions and so forth, it must be also made available to people who do it for religious purposes. Display of nativity in common areas during Christmas. If they permit residents to have seasonal displays without regard to their religion, then the seasonal displays will not violate the Fair Housing Act. I'm not going to go through it, and you can see information here, the guidance from HUD's Office of General Counsel. I didn't think this was coming up, but in doing trainings, there were complaints raised about discrimination by a resident manager as to the use of the community room, which tracked this guidance. And this came up in a training about 2 years ago. So it's something that does need to be reminded. Next compliance check is national origin. What are the issues with national origin? One is requiring that applicants have a Social Security number, or residents have a Social Security number. There is a conciliation agreement, Zuniga case versus residential management. It's a HUD-approved conciliation agreement, and it adopted or recommended these 14 pieces of documents that are sufficient to establish an applicant or a tenant's or an occupant's identity. What does this do? It does 2 things. It allows the housing provider to meet their reasonable need to establish the identity of a tenant or occupant or applicant, but it avoids discrimination against individuals based on their citizenship status or national origin status. So this would be a policy that should be adopted as sufficient to establish a person's identity. Sex discrimination. What are the issues that we see with sex discrimination? The main thing is inadequate reporting and investigation of complaints of sexual harassment. For compliance, we have on our website a sexual harassment in housing and employment policy and complaint form. Notice I have it both as to regular fair housing and employment, because there can be other kinds of sexual harassment that can involve staff. And so this is a short form. It's on our website. Also contains language to kind of prohibit retaliation against anybody who makes a complaint. And there's manager supervisor information, and there's information that can be filled out concerning the suspected harassment, and as talk about other previous complaints that are made. And you want to make sure not only is the complaint is received, but is objectively investigated in a fair, impartial way. These are the liability standards when it comes to what the standards are when it comes to sexual harassment. I have combating sexual harassment and domestic violence. There's a webinar and PowerPoint on that. Also, I have a webinar and PowerPoint on liability under the Fair Housing Act, which addresses neighbor-on-neighbor harassment. The last is source of income. Fair housing compliance check for source of income. What are the violations? Well, there's policies that give rise to source of income violations. I recommend that you look at this guidance for any source of income question. There's several of them that have been out there. Again, Michigan recently adopted source of income requirements, but they've been adopted previously in many other states. The best guidance out there is the one from the New York State's Human Rights Law There's a 2020 guidance there. Illinois Department of Human Rights also has source of income guidance. And New York City has a very good website when it comes to source of income discrimination. I have the links here. There's lawful source of income fact sheet, which is helpful. And then there's FAQs, 3 types. One for brokers, agents, and owners, another one for landlords, and a third one for tenants. I also have a legal outline, which is on our website, Michigan Source of Income Protections. And I kind of combined these and I added some other FAQs to come up with 26 technical compliance FAQs to make sure that they're not violating source of income requirements. Again, the effort is made to address most, if not all, of the questions that come up when it comes to source of income. In the remaining 2 minutes, what actions that may violate source of income requirements? Michigan source of income requirements. Michigan has a 30-day requirement. It says that excluding from source of income coverage, housing assistance that's not approved by the appropriate agency within 30 days after the landlord provides all information required as a condition of the agency's approval, including evidence that the repairs have been completed. In other words, while the application from a person with a voucher is pending, the landlord can't, it's been 7 days, been 10 days, been 15 days, I'm going to rent the unit to someone else. That would be a violation. Have to hold it for 30 days to allow sufficient time to get all the approval and everything fine so that the person can then be rented to. If an applicant is rejected prior to this 30-day period simply because the housing agent hasn't completed their process, that would consist of a violation. That's not the tenant's fault, not the tenant voucher holder's fault in that situation. So again, for compliance as to Michigan source of income requirement, look to our legal outline on source of income protections. I think it's worthwhile to take just 30 minutes to make sure that you're in compliance. And I think in a video format, you can always stop it, pause, take a look at what you're doing and go through it in a little bit more detail. Thank you for reviewing, and I hope you find this helpful to you in making sure that you're in complete fair housing compliance. Thank you.